Good afternoon, everyone. We're going to get started. My name is Alex Sarkov. I direct the Connecticut Sentencing Commission. Thank you so much for being here for these important conversations. We're going to turn next to an area that we've been discussing a lot recently within the Sentencing Commission, and that's competency to stand trial. I'll let the panel members introduce themselves, and then we'll get started.
Good afternoon, everyone. My name is Reena Kapoor. I am the Director of Forensic Services for the Department of Mental Health and Addiction Services. I'm also an Associate Professor of Psychiatry at the Yale School of Medicine. I've spent my whole career working with people who are involved in one way or another with the criminal legal system. So first doing court evaluations, including competency to stand trial. I worked as a clinician in the Department of Correction for a few years. I worked in community services with people who were formerly incarcerated. I worked at Whiting Forensic Hospital, and then since August of this year, I've been trying to fill the unfillable shoes of Dr. Norco as the new DEMIS Director of Forensic Services, and very happy to be here with you today.
I'm Judge Gerald Harmon. Good afternoon, everyone. I'm the presiding judge in New Haven for the Part A Criminal Court, which handles all the serious Part A felonies in New Haven. Prior to that, I worked in Meriden at the Superior Court there, and then at the Waterbury Superior Court prior to that. And then I was 20 years as a defense attorney in both state and federal court prior to being on the bench. So I've had a lot of opportunities to observe people who, unfortunately, due to their mental illnesses, end up in the judicial system. I think one of the things that's been reiterated here today is, unfortunately, the judicial system and the Department of Corrections has become the main treater for mental illness in this state and in many places throughout the country. I think we all can probably remember back, I can't remember what year it was, when they decided to close all the mental health hospitals in New York and in Connecticut and a lot of places, and all those mentally ill people were then put out onto the street. And unfortunately, a lot of those people end up in the criminal system. So we're trying to address that, and we look forward to having everyone here and people that understand that problem and understand the needs that the parties have in the entire system. So thank you.
Hi, everyone. My name is Bill O'Connor, and I have been a criminal defense lawyer for about 30 years. For the past 26 years, I've worked with the Division of Public Defender Services, mostly as a trial attorney and primarily in the Hartford court, where I realized for the first time that many of the people committing crimes don't just do it because it's convenient or something they choose to do, but they do have underlying mental health issues or substance abuse issues. And I found that a great percentage of my clients over the years really suffered from one or both of those disabilities. For the past 4 years or so, I've worked at our division's psychiatric defense unit, which is located in Middletown on the grounds of Connecticut Valley Hospital. And primarily, we represent individuals who have been acquitted by reason of mental disease or defect and have been committed to the Psychiatric Security Review Board. As Dr. Norco's presentation spoke about, those are our clients, and we represent about 70% of the individuals that are under PSRB supervision.
Good afternoon, everybody. My name is Kevin Lawler. I'm the Deputy Chief State's Attorney for Operations at the Division of Criminal Justice. I've been a prosecutor for about 29 years. And prior to my the last 5 years as Deputy Chief, I was also the State's Attorney for the Judicial District of Ansonia Milford.
Thank you. The first question is for everyone on the panel. By law, a defendant in a criminal trial may not be tried, convicted of, or sentenced while the defendant is not competent. What is competency to stand trial, and why do we have this process of competency restoration?
Okay, so as the non-lawyer in the group, I get to give the non-legal answer, which is, to me, as a regular citizen, as a mental health professional, it's wrong to put someone on trial who doesn't understand what's going on or who can't work with their lawyer to defend themselves. And so we need a way to push the pause button on the legal proceeding and to get people the help they need so that then they are able to move forward with a trial if that's what's going to happen. Sometimes it's a plea bargain. And what help they need varies. You know, it's a mental health symposium, so of course, like a lot of the people need mental health treatment. But sometimes it's other things too, like education about how the court works. We sometimes have people from other countries or who didn't go very far in school who need that education. Sometimes they're people with intellectual disabilities. Sometimes they're people with communication or cognitive limitations. So it's a lot of different kinds of things that we're treating to restore people to competency. But I think we have it because it's, you know, imperative upon us as a state, as a society, to make sure that people are well enough to go forward with a criminal proceeding.
In terms of that, and you look to the statute 5456D, which has basically, as Dr. Norco indicated, the 3 different avenues that you go to when you're assessing a person. So the initial person, you go say, is this person competent? They'll come back after the evaluation and tell us, yes, this person's competent. We've done the necessary review of this person. They're able to work with their attorney. They understand the legal process. They know who the judge is. They know who the prosecutor is. They understand each person's role, and they're able to assist in their own defense. So that's a big thing in Connecticut and some states. When we talked about other states, that's not such a big thing. You know, people's civil rights aren't as important as they are in Connecticut. So they want to make sure people are able to aid in their defense. Then you have, secondly, is the person restorable after a period of time within the statutory limit? Can they be restored? And what's the least restrictive method for restoration? So that's probably where the bulk of people who aren't found competent land in that category right there in terms of that. And then we'll order them for restoration. And when you say restoration, it really means just restoration to be competent to stand trial. That doesn't mean that they're suddenly cured if they had some mental illness, that it's suddenly cured at that point in time, or that they're getting proper treatment for that mental illness either. That doesn't mean that either. All it means is that they're just being, at that point, educated, either through education, as Dr. Kapoor indicated, or through medication possibly sometimes. They're not taking their meds like they should in terms of that, or some type of treatment that's necessary just to have them competent enough to stand trial at that point. Then you have the third category, which is a very small category of people who are incompetent and not restorable. These are individuals who will never be able to go to trial because they're never able to work with their attorney in terms of that. And that's a very small group of people, but I think Dr. Norco touched upon a lot of the problems that that group of people causes, or what happens when you have that group of people, and how society misconceives that group of people, or how we have to figure out how to treat that group of people also, because it's very difficult in that sense.
And I would add to that, you know, we use this term competency to stand trial, but the statute says that a person should not be tried, convicted, or sentenced unless they're competent. And in the criminal courtroom, it's a very, very small percentage of cases that go to trial. Less than 1% actually go to trial. So very often it's a matter of getting the person who is not competent to be restored to competency, just so that the case can proceed however it's going to proceed, even if that results in a plea bargain. And as a defense lawyer, I feel I have an obligation to make sure that my client is well enough and capable of assisting me to assist them to get the best outcome for them. So if there's a case, if a defense attorney has a client and has concerns about that client's competency, and the defense is presented with a plea bargain, most lawyers, myself included, would not feel comfortable having the client enter into a plea agreement, because there's real consequences when you enter into a plea agreement. You'll get a conviction. The conviction might be for a felony or for a misdemeanor, and that could have a permanent impact on a person's life. The person may have to be incarcerated, get a period of incarceration as a punishment, a period of probation, some sort of supervision, where there'll be sanctions if the person doesn't comply with the court orders. So before you set a person up for failure by advising them to agree to a disposition as opposed to taking the case to trial. You want to make sure the person really understands what they're getting themselves into. And I think most of the competency cases fall into that category as opposed to the people that are actually going to trial and appearing in front of a jury.
Now, I would just add to that a little bit that, I think also from your perspective, one of the other things that it's important to understand is that your client has to be able to survive a plea canvass where the judge basically has to ask a series of questions of anyone pleading guilty to any charge, that they understand the charges against them, that they're satisfied with their attorney's advice, and that they're willing to accept all of those conditions. So in order to be able to even just answer those questions truthfully, I think the parties have to be assured that the person is competent. It's important to understand that the law presumes competence under 5456D. So we don't have to prove someone is competent. Normally the request comes in, and then we have to have the hearing when one of the attorneys or one of the parties believes that competency may be questioned. And it's at that point that whoever the moving party is, the party that's asked for this report, to be able to prove by a preponderance of the evidence that a person is not competent at that point and subject to possible restoration. So from a prosecutor's perspective, I would say it's pretty rare in my experience that prosecutors ever ask for a competency evaluation, because it's rare for us to have that kind of personal interaction with most defendants in cases where they're seriously charged, because they're represented by counsel, and ethically we're not allowed to have direct conversations with defendants who are represented by attorneys. So I think it's normally the defense attorney who raises a competency question, or in some cases it's the court when people are acting up in court in ways that they find irregular, and the court can ask for a competency. So I think by our review of some of the statistics that we've had, it's somewhere around 5% of competency evaluations are requested by prosecutors. But it's our job, once a hearing is requested and a report is generated, to cross-examine those witnesses that are presented in those hearings to assure that we're getting a full picture of what this person is presenting as the case moves through this process.
Dr. Kapoor, can you give us an overview of the competency evaluation and restoration process in Connecticut and nationally? And then to everyone else, can you describe how the competency process works from your perspective of a public defender, prosecutor, and a judge?
Sure, but before I do that, I'm going to continue the trend of mental health professionals insisting upon audience engagement. How many of you actually have experience either in your work life or your personal life with someone who has been through the competency evaluation or restoration process? Okay, so a smattering of people, I guess I would say, maybe 20 in the room. So I think, trying to target my remarks a little more generally, that same word that you've heard all day to describe mental health services at this interface of criminal justice is probably the most common word you'll hear describe the national competency situation, and that word is crisis. And what you see across the country is that there have been, in the last at least 20 years, maybe longer than that, an increased demand for competency evaluation and hospitalizations for competency restoration. So just to give you a little bit of an idea, in a 2020 survey, when they asked the states, how many of you have seen an increase in demand for competency evaluations, 78% of them said yes. So in Colorado, they've seen more than 500% increase in their evaluations since 2000. In Washington, they've had an 82% increase. And so, as of 2020, there were 2/3 of the states had a wait list for someone to get into both a competency evaluation and a restoration bed. And almost 40% of states were facing litigation around that issue. They were being sued because of their inability to provide timely evaluations and restoration services. So what we see around the country is wait times for evaluation, wait times for restoration, no alternatives to inpatient restoration, and no jail diversion as an alternative to the competency process altogether. That being said, that is not the case in Connecticut. So you heard a little bit about that from Dr. Norco. We have been largely spared those problems. That we have never in Connecticut had a wait list for competency evaluations or restoration, that there have been these 3 brief periods in almost 20 years where the demand for restoration beds exceeded the capacity at Whiting, but those were kind of 3 months, 4 months at a time, as opposed to in other states these kind of chronic and endless and growing wait lists. We have a system for outpatient restoration that I'm sure we'll talk about could grow, but we do have that. And as you heard in the second panel, we also have a pretty robust jail diversion operation going on. And so I think all of those things have allowed Connecticut to avoid that label of crisis. And in fact, when the American Psychiatric Association a few years ago was putting together a position statement on competency assessment, the first draft of that statement, said that competency is in need of major reform in every jurisdiction. And it got changed over time to it's in need of reform in many jurisdictions, because someone on that work group had recently been to Connecticut and said, no, I think it works pretty well there. And so we, again, just to sort of say that some things the state does well, even though we could always do better, we don't have the same kind of challenges. But hopefully some of the rest of the time on the panel will be talking about areas in which we can improve still.
And I think that part is important to touch upon, though. Even though we may be doing much better than a lot of the other jurisdictions or states, we still have a lot of room for improvement also in terms of that. And as a judge, you see competency exams used in different ways. Also, sometimes I'll call a case in for trial. Suddenly the attorney will say, hey, I need a competency exam for this person before we're ready to go forward with the trial. And I'm wondering, why didn't that happen during these past year when the case was pending during that time? But sometimes for them, there's 2 reasons in terms of that. Maybe they do want to make sure their client's that competent before the trial, before it happens, before they feel that they can go forward at that time. But at other times, it's maybe they just want to delay this for a little while. Maybe they want to have some more time just for that. And as a judge, it's difficult because you haven't had that interaction with the client, with that person that they're dealing with. You haven't had that one-on-one interaction. So it's hard for you to say as a judge, hey, I think that person's competent. I'm not going to order that exam. That's just not going to happen. So you can't do that as a judge. You say, well, if they think that's the case, I'm going to have to go ahead and order that, because otherwise I'm just lining myself up for a habeas or some type of other case that's going to happen down the road because I didn't give them the opportunity to get that person to that stage. So I think that there's a lot of room for improvement in different aspects of it in terms of that we can do, and I think the steps are being taken for that. I mean, the idea of more outpatient restoration is a wonderful idea. A lot of times it's always our least restrictive is inpatient restoration for the most part in terms of that, just to keep, I think, control and the parameters around the client. But unfortunately, that's not the only answer, and we really have to figure out a way for that not to be the answer each time.
To follow up on what Judge Harmon said, I'm sure there are defense attorneys who view the competency examination as sort of a tool in their toolbox that they can use at the appropriate time, maybe to delay, or maybe in negotiation. Well, if you're, state's attorney, if you're going to offer him, if you want him to plead to a felony, well, then I'm going to have to ask for a competency, something like that. I've never done that, but I view it more as protecting the client. If the case is actually going to trial, and as I said, most don't, it's a team effort. You've got a lawyer on the team, maybe two lawyers that are going to trial, a paralegal, a social worker, an investigator, all working on the trial. And, the client is part of that team. The client is the most important person on the team. It's all about the client, after all. It's their life. And, you need that person, the lawyers need that person to be fully engaged and fully capable of being engaged. The person has to be able to sit there at their own trial and have the ability to listen to testimony all day long for several days in a row, potentially, and monitor that testimony for inaccuracies and have the ability in real time to lean over to their lawyer to say, that's not right, and be able to help the lawyer help them at their own trial. So if the person isn't capable of doing that because of psychiatric symptoms or because of intellectual disability, something, then they're at a disadvantage. And the lawyer's at a disadvantage defending that person. Some people may say, well, what does it matter if the defendant, if the accused is competent? As long as they have competent lawyers that know what they're doing, they can protect the person's rights. Well, that's true to some extent, but if it's going to trial, that person really needs to be fully engaged. So I view it as a way to protect the client in those situations more than a tool that a lawyer can use to strategize.
And I would echo a lot of those comments. I mean, I think in the course of my career, I've seen it used, in all of those ways to a varying degree, whether it be, I would say it's a rare occasion where I see it, where I would believe it was a delaying tactic, but that, that is out there. But, I think that from a prosecutor's perspective, we really have no skin in the game as far as, whether a person is competent or not. That's up to the counsel who's ethically obligated to represent their client in the best way they possibly can, to ask for that when it's required, and it's up to the medical professionals to evaluate that person under the legal standards that we have. So, from my perspective, we just kind of see it as another step in the process towards trying to resolve the case. Now, I do see defense attorneys who I think probably use it also from the perspective of kind of getting a more in-depth mental health picture of their client, and they can more effectively advocate to the judge in pretrial negotiations once they've kind of gotten that perspective through a competency eval. Whether that's what it's intended for or not, I don't think it is, but it is something that I think is a tool that is used to kind of present that that type of workup for someone who normally is incarcerated, normally doesn't have a, like a private doctor that if you were someone of some means and had a lengthy mental health history, you could call up and say, hey, doc, here's the waiver for your client, and I'd like to be able to see all of his mental health records. You're not really going to get that. So this is kind of, I think, one of the ways that it's used. That isn't its intention, but I think it also leads to some of the increases that have been seen in mental health evaluations over the course of the 20 years, as Dr. Norco's slide projected. But I think that, what it does point out, and I think that everyone here is correct in that, the system, certainly compared to other parts of the country that we've all seen in our travels, works better than most. Where there is room for improvement, some of the things that we're going to talk about a little bit later on about how this system is incorporated into things like people who are solely being prosecuted for misdemeanors. What can we do differently? What are some of those diversionary programs that were up on those slides earlier that have shown more promise than others? To be able to try and get people out of the criminal justice system and into more effective mental health treatment that will provide both a benefit to them and a benefit to society, right? Because I think that's what we're all trying to do. I think everybody on this panel has kind of two hopefully parallel goals in mind. One is to protect the public, and one is to get the person who is obviously in need of mental health treatment, effective treatment that helps with goal number one. And I think that those are just some of the factors that we're all always trying to consider as we deal with these very difficult issues in criminal court.
Thank you. Next, I'd like to get your thoughts on some policy areas related to competency. First, competency evaluations and restoration for people charged with a misdemeanor. What does the data tell us about misdemeanor cases, and how do we make sure that the lower level cases are diverted from the criminal legal system?
Maybe we can start with Kevin.
Sure. It's like law school. You want to go first just to get it over with, right? No, I think that, with misdemeanor cases, this is something that, I was along with Chris Burke and a number of other people who are seated here with me today on the trip to Miami where, we were able to get exposed to, a different way of doing things. And, this was one particular area where I think that there was common agreement among all the parties that we should be doing better in this particular area. That, getting people who are solely in on misdemeanors, who have clear mental health issues, that we shouldn't be taking up, a vast amount of resources, I think, on competency evaluation, just to be able to get them to the point where, as my colleagues here have talked about, just to get them to either plead guilty to a very minor offense or to do something else and put them in a program, that doesn't seem to be a good fit. And I think that I speak for all the state's attorneys and certainly Chief State's Attorney Griffin, where we are certainly amenable to trying to do something different with that particular population, because when it's chronic misdemeanors, the public safety aspect is obviously lessened because those crimes are by statute deemed less severe. So we should be able to figure out a way of getting those people who need treatment, who are kind of chronically offenders, but are not offending so seriously as to warrant more public safety emphasis, that we should be able to do something. So one of the things Chris Burke was talking about, we strongly believe that our ESI program, which tries to divert folks out of the criminal justice system even before their first appearance in court, that through the use of social workers who are contracted, don't work for the Division of Criminal Justice, but are contracted, can identify these types of individuals that are in this kind of catchment and be able to refer them directly out to local providers, whether that be the respite bed program that has been successful in Bridgeport, or other community service providers. And we should be able to do that to get them back into treatment. Most of these people, in my experience as a prosecutor, have a mental health history of treatment beforehand. They're either are not, or they're neglecting it, or they don't have they can't afford the medication anymore. So getting people back on track is more important than devoting those resources to just making sure they know who their lawyer is and what the judge's job is. So I think that using a program like that and some of the other suggestions that kind of came out of our Miami trip are things that the Division of Criminal Justice supports to try and target this specific population to get better outcomes, both for the people who are chronically offending, for the victims of those crimes, because, those people, again, they just want to see the activity stop, right? And also for the system as a whole to get some more benefit out of the system, as opposed to just keeping people on a hamster wheel that doesn't really provide any good outcomes.
I agree with everything Kevin said.
Good. Start tomorrow.
Right. So I guess we've settled it all.
I'm glad we could. Can we go now?
But we, just to put a little more perspective for the non-criminal defense lawyers in the room, very often a chronic repeat offender for misdemeanor type offenses comes into the court, and they have a prior history, so they're held on bond, even though the charges might be misdemeanor. So they're going to spend a few weeks in jail while they're appointed an attorney. The attorney talks to them. The attorney determines, gee, this person really isn't competent. That attorney then files a motion for a competency evaluation. That takes a little bit of time. And if the result of the evaluation is that the person is not competent but can be restored to competency with inpatient treatment, you might be 2 months to 3 months into the person's incarceration by that time. And then the person, if the judge orders it, would go to Whiting Forensic Hospital for either 60 or 90 days of inpatient restoration treatment, a maximum security hospital. So, remembering that misdemeanors carry only, by definition, a year in jail or less as the maximum penalty, you might have a person who, when they finish that restoration process, is now restored to competency so that they can deal with their case or go to trial, however they choose. They've now been off the street and either incarcerated or in the hospital for a combined 4 to 6 months in some cases, maybe longer in others. So I think what happens at that point is the defense attorney and the state's attorney, because the person has been off the street for all that amount of time, they come to an agreement that, that's probably enough. They don't need any further incarceration. And then the case doesn't get prosecuted, or they work out a plea agreement where the person is just released from jail. And then, the efforts that might have been made to hook that person up with services often fall apart because the person gets their freedom again, the court case is over, and they go off and do their thing. And that's the frustration that the system gets with the repeat offenders who, even though resources are spent and efforts are made to get them on the right track, they don't always stay on that track. And great amounts of resources are spent on charges that really are not what anyone would consider serious charges. So I wholeheartedly support the effort to divert as many of these cases from prosecution to begin with as possible. The best kind of misdemeanor client that we can have is no client, not knowing about the case even because the person wasn't arrested, didn't come onto the radar of the defense attorney and got the help that they need. That would be the ideal situation.
That would be ideal. Unfortunately, it's not what we have all the time, but it'd be, that's a great idea. I like the way, I hope it works out that way eventually, but I think we are dealing with individuals who are chronically committing the misdemeanors. Unfortunately, they do end up in the system. We do need avenues to keep that from happening before they end up in the court, before they end up with that initial arrest. But when the individual's out there and let's say they just steal a pack of gum every day from the convenience store, that convenience store owner's like, how are you gonna let this person keep coming in my store every day, stealing another pack of gum? What are you gonna do about that? What's gonna happen with that? So I think that we have to have more, which I think we're working toward, more treatment provided for those people so they're not incarcerated. Have some type of, when you look at that, say this person doesn't really need to be incarcerated, they need to be getting treatment at this time, and then we get to the resolution of their case, which could result in a non-conviction just because of the treatment that they've had. But at least even if it results in a conviction, at least they've had treatment and they're moving forward at that point in time. So I think that's what we're all trying to work toward.
Yeah. I guess the other thing I would say, though, and maybe a little bit controversial, is that treatment alone is not the answer to keeping people out of rearrest and incarceration. Like, I wish it were so simple that psychotherapy and medication could stop people from getting reincarcerated. But it's not that simple. There are very few people who steal a pack of gum because voices as a result of schizophrenia told them to. There are a lot of other factors that are important here that have to do with people's basic needs, not being met. Housing, food, vocational needs, a way to support themselves, to have self-esteem, to have relationships with people. All of those are important too. And so as much as I absolutely agree that mental health treatment is a huge piece of this puzzle, it's not the only piece, and I think that, Alex asked about research and data. That's something that's pretty clear, is that, you don't just sort of snap your fingers, put people in a mental health treatment program, and solve your rearrest and incarceration programs overnight. So I'll just add that as well.
Thank you. We touched on this a bit already, but what are the alternatives to inpatient competency restoration? Are there sufficient options for community-based outpatient restoration, and are these options being utilized?
All right, this one I got. So the alternatives to inpatient restoration are outpatient restoration. That one's not hard. And then the thing we haven't talked about, because it doesn't exist in Connecticut, but that other states do is jail-based competency restoration. So, right now in Connecticut, we do about 90% of our competency restoration inpatient, and about 10% are outpatient. We can probably do better over time with that. I think some of the challenges to doing more cases outpatient are that it's oftentimes the person who's the clinician for the Office of Forensic Evaluations who's making a recommendation to the court about what's the least restrictive environment in which restoration can be accomplished. So some of the things that they're looking at are like how acute are this person's mental health symptoms? Like even aside from the competency question, do they just need to be hospitalized? So that's an issue, is acuity of symptoms. How likely are they to cooperate with treatment? Because if someone needs medication and they don't want to take it voluntarily, the only place you can do that involuntarily is in a hospital. Are they actively using substances, so that, even if you're able to provide education or services to them in the community, is the substance use going to prevent them from absorbing the education? That's an issue that comes up. Does the person have stable housing? Do they have a place to lay their head at night while they're in this outpatient program? And then do they have transportation or some way to get to the outpatient program, the services that are being provided? And so that anyone who is a public defender or prosecutor who's worked in this space knows that that's a relatively small subset of people who have stable housing, transportation, aren't using drugs or alcohol, willing to cooperate with treatment, aren't so ill that they need a hospital level of care. And so right now, that's why we do so much of our restoration inpatient. So the way to enhance the outpatient services is to kind of tackle some of those root causes. So can we build a residential program so that people have a place to live during their restoration? Are there other, housing resources we can draw upon? Can we create a program where we're also providing substance use treatment? All of those things, I think, if we can offer more robust services in those areas, I think that will help the courts ultimately feel a little more confident in allowing or recommending outpatient restoration.
Can I just do a quick follow-up question? Can you give us a sense of how much competency restoration actually costs?
Sure.
I mean, inpatient restoration.
Yeah, so we asked our fiscal people for an updated per day bed cost at Whiting, and they said it's around $2,000 a day. And so if your average inpatient restoration is somewhere between 90 and 100 days, you're looking at about $200,000 per restoration. And so when you put that together with what if this person's top charge is just a misdemeanor? That's a lot of money and a lot of the state's resources being spent on what oftentimes, as Bill was saying, ends up being no further prosecution happens once they get out of the hospital.
So I would just add, in my experience, doing this for many years, I think I've maybe had two clients where, when I filed a competency motion and they were found to be not competent but restorable to competency, only twice where the recommendation was that the treatment be on an outpatient basis. And in both of those times, the individual was not in prison, was in the community. And for the reasons that Dr. Kapoor mentioned, they're going to need stable housing. They're going to need somebody to make sure they get to appointments. because the restoration on the outpatient basis is going to be, maybe once a week they're going to come and meet with a clinician who's going to educate them on competency or provide them with some sort of, maybe they need medication or something that's going to get them to be able to, to get their symptoms under control. Whatever the case is, by far the number of individuals where the attorneys are asking for competency exams are not in the community. They usually end up incarcerated because they're going through life problems that have led them to this point in their life where they don't have stable housing, where they have a substance abuse issue, where they don't have employment perhaps, where other things are going on. So it's a combination of maybe there's not a lot of outpatient restoration options available, but most of the individuals in that position really aren't amenable to outpatient treatment anyway. I wish they were. I mean, it shouldn't be that a person with misdemeanor charges has to spend weeks in a prison followed by weeks or months in a maximum security mental hospital. It should ideally be that that person can stay in the community and avoid any incarceration and be restored to competency so that they can adequately deal with their criminal case. I would love to see an increase in that, but I also understand why it isn't currently very widespread, the use of outpatient restoration treatment.
Just quickly to echo on some of that, I think, some of the things that we saw when we went down to Miami are very different, obviously, than what we do here. And I think that a lot of what we've talked about here already, as far as those other services that are provided, like down in Miami, they had the 7-story building where everything is kind of one-stop shopping, and that you have a lot of the other services that are required to kind of go hand in hand for people in this particular situation in order to give them a chance at success is really needed. So, for me, I think what we have here is really the all or nothing options is really all we have here. We have inpatient, and then to a small degree, we have outpatient restoration services. And I think that we need, if we are going to move away from the inpatient model, which obviously is very costly and in this particular population, perhaps not the best fit. We need to have something else that kind of talks about some of those best practices in order to have a chance to succeed. And then I think also we need to have some sort of an intermediary step up for people who don't embrace that particular mode of restoration that is short of the inpatient that we currently have now. I think something in the middle probably would need to be devised, and that's what I would leave to all of you to come to think of and talk to our state representatives who are here about how to formulate that. But I think that those are some of the things that we should be working towards.
And I think a lot of it comes down to possibly, somewhat of a cost analysis. As Dr. Kapoor was saying, if it costs $200,000 to bring one person to competency, and that is just for the purpose, and that's remembering that people vary in competency throughout the length of their proceeding also. So someone might not need one competency exam, they may end up needing 3 or 4 exams before their case is resolved at the end in terms of that, because they go in and out of competency due to their at-whiting, then they go back to DOC, and during that entire time they're maybe not getting the appropriate treatment, so they'll change in their competency standards throughout that. So it's important to look at it like that, and then maybe we present to someone and saying, hey, this is what the cost savings is going to be if we had a residential place for these people to go, or had the services in one place or somewhere for them to go where they could receive it, and they'd have some control over that person to make sure that they were restored or received their proper services at that time. So that's probably something that we need to work on also, just people seeing the cost effectiveness of the appropriate treatment, and using treatment in a broad sense also, as including residential, not just mental health treatment also.
I think we have time for one quick question from the audience.
My question is how often this scenario happens. So my son was sent to waiting for competency restoration. And by the strict definition of restoration, he was deemed restored. So he spent months at waiting and was deemed restored. But as I'm listening to the panel, restoration includes, and this is my understanding, it should include his ability to act in his own defense. He was never at that point, but he was released. But the definition of competencies, there seems to be like a test that's used to determine whether somebody is competent to stand trial, and that bar and being able to act in your own defense, from my own experience, are two very different things. So I'm just curious what is being done to address that.
I could take a stab at that. I mean, in my career, I can think of two clients where I challenged competency on and ultimately was unsuccessful. And both of the individuals were similar in that they had mental illnesses, they had symptoms at times, but they also had a propensity to, I won't say act up or act out, but they were deemed by some who interviewed them as malingerers or exaggerating symptoms. So ultimately, they were found to be competent, and although we disputed that, the court found them to be competent because, as you alluded to, it's a pretty low bar to get over. If you can do certain things, if you can parrot back what certain legal terms mean, then you can understand the proceedings against you. It's really the second part of that. Are they really able to assist their attorney? And sometimes the expert opinion is, well, they have the ability to assist their attorney, they just choose not to, for whatever reason. And those individuals really are at a big disadvantage if the case goes to trial, because they're not fully participating with their defense team. And in the two cases I'm thinking of, it didn't end well for either of them. Now you could say, well, maybe those individuals, that's the way how they deal with the guilt over what they've done, because these were very serious crimes. You can't say that in every case, of course. But I think that a lot of individuals do fall kind of in the middle, where they're truly not able to assist their attorney as they should be because of a mental illness, but yet they also meet the legal definition of competency. So the case goes on. And I don't have an answer for that, but I have seen it happen in my career.
And I think what Bill alludes to as well is, the low bar that is set for competency to stand trial is different, obviously, than if a not guilty defense of mental disease or defect is put forward, which doesn't focus on how you are now and that low bar, but on what the person was experiencing at the time of the alleged crime. So that becomes something much different, and that's a different medical bar that needs to be cleared. So that's probably, in those types of cases, if it was a serious case, that's probably where the defense would end up, and that would be what the trial is really about.
Okay, well, that was quick but to the point. I'd like to thank our panel members. We'll take a very quick break and then head to the next panel. Thank you.